Since we are talking about constitutional remedies, we should first know what this term actually means. In the legal sense, a remedy means a solution, a way of solving a problem, or a restitution for a harm or damage caused. If this solution or restitution is achieved through a court decision or a court order, it can be called a legal remedy. Part 3 of the Constitution guarantees several fundamental rights. These fundamental rights are primarily enforceable against the state, mainly against the legislative and the executive. Now, what happens if these fundamental rights are violated? For example, if a person is facing discrimination due to religion, caste or sex, that would be against the person's fundamental rights as guaranteed under Article 15. The person would normally approach the state, that is, the government or the authorities, to help enforce his or her fundamental rights. But what if the government is not helping in enforcing the fundamental rights? Or the government itself is violating those fundamental rights? This is where the Constitution not only guarantees the fundamental rights in Part 3, it also provides a mechanism for approaching the courts for enforcing those rights. Since these remedies are provided in the Constitution itself, they are called constitutional remedies. The existence of these constitutional remedies also supports a very important legal maxim, ubi jus ibi remedium, which means if there is a right, there is a remedy. A right is a right only if it can be enforced. So the Constitution gives the right, and the Constitution also gives the remedies. Dr. B.R.Ambedkar considered Article 32 to be the heart and soul of the Indian Constitution.